Good morning. My name is Roni Stauber. I'm the director of the Goldstein-Goren Diaspora Research Center, and I'm pleased to welcome you all to the International Conference, 70 Years of Holocaust Compensation and Restitutions. Mr. Dani Dayan, the chairman of Yad Vashem, Mr. Schneider, the executive vice president of the Claims Conference, Mr. Steffen Seibert, ambassador of the Federal Republic of Germany to the State of Israel, Professor Milette Shamir, the vice president international of Tel Aviv University, and we will be honored later on also to hear the pre-recorded greetings from Ambassador Stuart Eizenstat. Dear lecturer and participants from Israel and abroad, ladies and gentlemen, on February 21, 1952, exactly 1 month before the commencement of the direct talks in Wassenaar between the delegates of West Germany, Israel, and the Claims Conference on the global compensations, Israel Foreign Minister Moshe Sharet wrote a letter to Melech Neustadt, a high-ranking official of the Histadrut, the General Organization of Workers in Israel. During the war, Neustadt was very active in collecting information and making it available to the Yishuv in Eretz Israel on the fate of the Jewish communities. Sharet answers Neu's recommendation to include in the Israeli delegation to Wassenaar people who, like himself, have spent time and effort to accumulate information and to study details about the destruction. Neu wrote that the German delegates to Wassenaar would probably repeat the claim that the Germans should not be blamed for the fate of the European Jews. In his answer, Sharet made it clear that the Israeli representatives do not intend to enter into a debate about the responsibility of the German people. He stressed that the negotiation would only be about payments, dates, and forms, not on moral and historical accountability. And indeed, in Wassenaar, the Israeli delegation declared at the end of the opening statement, and I quote, that time has not yet come for historical account. Both Israel and the Claims Conference adopted this line. It created de facto separation between accepting compensation, global or for individuals, and avoidance of the lack of thorough reckoning of the Germans with their past wrongs. Communal liability, to quote the philosopher Karl Jaspers, for crimes that couldn't have been committed without collective silence. This separation line emerged following Konrad Adenauer's historic speech on September 27, 1951. Despite Israel's leaders' expectations, the Chancellor acknowledged only indirect German responsibility for the crimes committed in the name of the German people, im Namen des deutschen Volkes. This phrase became a symbol for what the historian Norbert Frey called years ago Vergangenheitspolitik, policy for dealing with the past. It was part of the policy of amnesty of Nazi criminals and the integration of ex-Nazis led by West German government and the political elite during the Konrad Adenauer era. It enabled even hardcore Nazis to begin new careers or continue old ones. The myth of the clear distinction between Nazis and Germans was designed to whitewash German society moral responsibility for the crimes of the Nazi regime, particularly the persecution and eventually the destruction of the European Jews. At the beginning of 1953, after the ratification of the Reparations Accord, Social Democratic Party leader and the Bundestag deputy chair, Carlos Schmidt, said, and I quote, "It would be a disaster for Germany if the Germans were to think that they bought forgiveness by ratifying this agreement and that now they can move on to business as usual with Israel and the Jews." Schmidt's warning was well-founded. Historian Saul Friedlander wrote that for most German official expressions of repentance and initiatives of reparation seemed sufficient as ersatz, substitute for memory. Israeli critics argued in the 50s and at the beginning of the 60s that the German leadership exploited the compensations and towards the end of the 50s, the economic and the military support for Israel as a way to moderate criticism, both external and internal, for the wall of silence it had erected around the Nazi past. They also criticized Israeli and Jewish leaders for not attacking Germany's attitude towards the past, particularly for not bringing Nazi criminals to justice and for integrating ex-Nazis into the Federal Republic administration, even in the highest positions. On April 1960, Israel Gutman, a survivor of Majdanek and Auschwitz, ex-member of the Jewish Combat Organization in the Warsaw Ghetto, who later became one of the leading scholars of HaShoah, he wrote, and I quote, "A government that accepts reparation agreement but does not insist on punishing criminals inherits only the financial reparations of those murdered, but does not inherit their spirit and does not uphold their last will." The claim that Israel and the Jewish leadership had to pay more price for their agreement with Germany is well-founded. However, it is important to note that in the eyes of the three leaders, Ben-Gurion, Sharet, and Goldman, the head of the Claim Conference and the World Jewish Congress, who led the breakthrough towards the reparation agreement, the interrelation between reparations, memory, and accountability was much more complex. Accepting responsibility by West German state for the persecution and the murder of the Jews, for the crime initiated during the Nazi regime, a result of the economic support for Israel, and the personal compensations and the reparations, was seen by them as a historic achievement for the state of Israel and the Jewish people, whose importance cannot be overstated. For the three leaders supporting the Jewish state, the rehabilitation of Jewish communities, and the agreement on future legislation to compensate individuals was the foundation for the future in-depth national reckoning. During the stormy debate on January 1952 over the question of opening direct negotiations with the Germans, Ben-Gurion, Sharet, and other leading members of Mapai emphasized that for the first time in history of persecutions, Jews as a collective entity and as individuals received compensation for actions that were committed against them. They claimed that this demonstrates the transformation of the Jewish people underwent. Establishing the State of Israel enabled them to demand reparations. It also shows a unique solidarity between Israel and the Jewish communities in the diaspora. The Israeli leaders related to national aspect. Still, from the universalistic point of view, it was the first time in human history that compensation was paid to persecuted individuals and not to countries. Demanding and paying compensation raised complex philosophical, theological, judiciary, and ethical issues, such as the essence of reconciliation, collective guilt or responsibility, historical accountability, and its impact on collective memory. In his well-known speech in 1966 on German and Jews, the eminent scholar of the Kabbalah, Gershon Shalom, said, "Abysses are flank open by events, bridges built by goodwill. Bridges are needed to pass over abysses. They are constructed. They are the product of conscious thinking and willingness." In the next 3 days, we will discuss the developments, the impact of the Luxembourg Agreement from a wide range of perspectives: historical, diplomatic, legal, economic, and social. We will hear about the continued struggle for reparations of Jewish property and about recent campaigns such as handling looted cultural property by the Claims Conference, the claims of Jews from North Africa and Middle East countries for compensations, and so on. There is no doubt that these discussions will involve difficult questions about the memory and historical accountability. So, ladies and gentlemen, it is my pleasure now to thank all our colleagues who helped us over the last year to organize this conference. And first, to our friends from the Claims Conference, Ms. Karen Heilig, Dr. Wesley Fisher, and the New York team, Rabbi Lee Beckman, the director of the Claims Conference in Israel, and his team. Karen, hi. In the name of all our staff, Sarah, Adi, and myself, I want to tell you that it was a real pleasure working with you. And as I told you, we don't know how to continue without the daily emails, the weekly and the daily emails from you. You became actually one of the staff. My deepest thanks to our friends from Yad Vashem, Professor Dan Michman, the head of Yad Vashem International Institute for Holocaust Research, and Dr. Yael Nidam Orvieto, the director of the Institute. Many thanks also to Dan Tadmor, the CEO of the Anu Museum for the Jewish People, and his staff, particularly Sarit Uri. The members of our academic committee, Professor Dan Michman, Professor Chavi Dreyfus, Professor Zoje Brunner, Professor Lior Abilski, Dr. Wesley Fisher, Professor Konstantin Goschler, Professor Stefan Lenstadt, Professor Michael Basiler, and Dr. Yael Nidam Orvieto. The academic institutes, our partners in this conference, the Minerva Center for Human Rights, Tel Aviv University, the Leo Baeck Institute, Jerusalem, for the study of German Jewish history and culture, the Jacob Robinson Institute for the history of individual and collective right, the Hebrew University, and also to thank the Go-To film, the distributor of the movie Reckoning, which we will watch this evening. We'd like also to thank Dr. Sharon Livne, Dr. Iris Nahum, and Professor Regula Ludi. They organized and coordinated the workshop on the Luxembourg Agreement of the Luxembourg Agreement Research Group of young researchers. The group met several times during the year before and towards our conference to discuss issues related to the conference. This is also a good opportunity to thank the Claims Conference for the scholarship granted for 5 researchers to write studies on topics related to our conference. We also thank the Dean of the Faculty of Humanities, Professor Rachel Gali-Cinnamon, who always provide moral support, and to the Goldstein-Goren family, who support the work of the center. And last, and certainly not least, I would like to appreciate my gratitude to my wonderful colleagues from the Goldstein-Goren Center, Sarah Apple and Adi Moskovich. They did, as you know, they did, as all of you know, a fantastic work organizing the conference, always with smile and good spirit. I thank them, I believe, as we saw, in the name of all the participants who learned to know them during this year, and to the other staff members of our center who helped Sarah and Adi, Anat, Shimrit, and Sharon. I really feel fortunate to work with such a brilliant and devoted staff. So now we'll move on, and our first speaker will be Dani Dayan, Mr. Dani Dayan, the chairman of Yad Vashem. So Dani Dayan, the chairman of Yad Vashem, the World Holocaust Remembrance Center. Prior to his position at Yad Vashem, he served as Israel's consul general in New York. Previously, he served as the chairman of Yesha Council, and before that, the chairman of the board of Elad and the CEO of Elad Software System Ltd, a company he founded. In addition, Dani Dayan volunteers as the head of the advisory board of Nefesh B'Nefesh, and until his position in New York, he was the member of Yad Vashem Council. Dani Dayan holds the master's degree in finance with honors from Tel Aviv University and a Bachelor of Economic and Computer Science cum laude from Bar Ilan University. Please, Mr. Dayan.
Thank you so much. So yes, I am an alum of this university. I hope that's not the only reason I am being given the floor. First of all, I would like really to thank all our partners in this event, Tel Aviv University, the Faculty of Humanities. Probably at this point in time is a good opportunity to advise the incoming Minister of Education, whoever he or she will be, that humanities are extremely important and should be strengthened. The claims conference, with which we have for many, many years a very close collaboration, and I hope I can say that it's even expanding collaboration. And this museum, ANU, that hosts us here, thank you so much to all of you. Actually, when I was approached for the first time and asked whether we should be among the hosts, among those that give auspices to this conference, I said obviously immediately a positive answer. But then when I was approached personally to give opening remarks in this conference, my heart lost a bit. Probably you know, those that are familiar with my background, that I consider myself a proud disciple of Menachem Begin. For me to stand here and speak in a conference about the Luxembourg Accords, about the reparations, about the Shilumim, is not an easy task. I never visited Germany in my life, in my 67 years in 2 weeks. I will become a senior citizen in 2 weeks. But I will. I received an invitation from the chairman of the Speaker of the Bundestag to come ahead of International Holocaust Remembrance Day to Berlin to open an exhibition in the Bundestag, and I am preparing myself for that task. The Shilumim, the reparations, posed the young state of Israel with a very poignant moral dilemma. And as most dilemmas, I don't think it has a clear-cut response. It has a clear-cut solution. In Hebrew we say, אין לזה פתרון בית ספר. On one hand, as in many, by the way, in many debates between those two great men, David Ben-Gurion and Menachem Begin, there was the pragmatic need. Probably, I'm not an historian, but probably the Shilumim, the reparations, were provided the very existence of the State of Israel. On the other hand, the more dogmatic or ideological position of fearing that those reparations could be a kind of bleaching solution for guilt and remorse. Probably I must be candid. Probably as time passes and we have a retrospective view of those 70 years, as in many cases, I start to appreciate more David Ben-Gurion than earlier in my life. This is not the only case, I must admit. But it's still a dilemma. For me as a person, I believe that also for the Jewish people, and I must admit that in my way here to the Tel Aviv University, listening to the radio in my car, and listening to the Constructa ad about German technology, how efficient it is, I still feel very, very uncomfortable with that. But now we have a different dilemma. Those are dilemmas that historians will deal with. You will deal with it today and tomorrow, and not only with the dilemmas, also with the practical outcomes. But today, I believe we have a different kind of dilemma. I wouldn't say no less poignant, but still very relevant. Unfortunately, but also inevitably, that's biology, we are approaching the post-survivors era. Actually, right now, already now, their numbers are dwindling. Every single day, I receive a message about this Holocaust survivor that one of our testimony, men and women in Yad Vashem that passed away, their number is dwindling, and by definition, also the causes to which those funds should be allocated to have to change. And I ask myself frequently, what is the common denominator? What is the things that Holocaust survivors, and I may say with the necessary care, Holocaust victims agree upon? There is no need for me to be told that Holocaust survivors and Holocaust victims were diverse as the Jewish people. There were ultra-Orthodox, and there were atheists, there were Bundists, and there were revisionists, there were Zionists, and there were anti-Zionists. I will never dare to speak in the name of the Holocaust victims on any other issue but one, their memory, remembering them. On my first day in office, that was August, as chairman of Yad Vashem, that was August 23, 2021, I was taken to a tour of the campus of Yad Vashem. That was actually the second thing I did. The first thing was to meet two Holocaust survivors that still work in Yad Vashem. One from France, one a former Catholic priest from Poland that discovered he's Jewish and made Aliyah. And they took me to the Museum of Art of Yad Vashem. I don't know if all of you are aware that we have in Yad Vashem a museum of art with artworks that were mainly paintings that were made during the Shoah or immediately after by survivors. And on one wall I saw a quote in English, in Hebrew, although I know now that the original is in Yiddish. And it is the last will and testament of Gela Zekstein. Gela Zekstein was a painter in the Warsaw Ghetto. She continued to paint and then to draw because she didn't have colors or canvas. So she hid her works of art in the Ringelblum archive along with her last will. She was a staunch Zionist, but she wrote in Yiddish. And she wrote there, and I'm quoting from my memory, not verbatim, that I know I am doomed. Indeed, she was. She perished. Her husband perished. Their 3-year-old daughter, Margalit, perished. But I bequeath my works of art to the Jewish museum that will be established after the war. When I saw that quote, I almost fainted. Because here she was, Gela Zekstein, speaking about Yad Vashem. Suddenly I understood, with all the weight on my shoulders, the responsibility that we have taken upon ourselves of fulfilling her will, her last will, 6 million last wills. And this is basically the common denominator that we have to remember, no other. When I came to Yad Vashem after succeeding a very talented chairman for 27 years, Avner Shalev, that did great things in Yad Vashem, I had to think, what is Holocaust commemoration today? How do you commemorate the Shoah today? And coming from the business world and having a wife that is a marketing director of a big organization, I said, okay, in marketing you say that one message. Go with one message and run with it. So I hired a company of advisors to think, what is that message? And they brought me 8 alternatives. No one worked. I discarded all of them. The Shoah is too vast an event, and the time that passed since is too narrow, too short to have perspective. We needed 4,000 years to understand that Pesach is about freedom. 80 years are not enough to understand the Shoah. We needed 2,000 years to understand that Tisha B'Av is not only about destruction, but is probably even more about Sinat Chinam. It took us 2,000 years to understand that. Therefore, I think that Holocaust commemoration today is first and foremost about telling the story. We have to tell the story to as many audiences and in as many diverse ways as possible, especially in the post-witnesses era, because the post-survivors era will be the era of the happy hour of the denialists and the distortionists. But in order to tell the story with authority and win, there are 2 preconditions. And this is very relevant, I believe, to this conference. The first one is documentation. We will not be able to tell the story authoritatively if we are not based on a sound, robust, the most robust possible base of documentation. That's the reason that in spite of the fact that we have in Yad Vashem 220 million pages of document, we continue. There is a difference between those 220 million and what we will have. We will know when we will have 300 million. The Vatican and other places. And the documentation has been extremely extremely beneficial in the things that we speak about also in this conference. The fact that we, from the former Soviet Union, we gather so much documentation, a huge project that allowed Holocaust survivors from the former Soviet Union to maximize their rights on this topic that we are talking about, or recently the research that was made based on documentation from the Shoah in Romania and Transnistria that allowed Holocaust survivors to be granted rights that they didn't have earlier, etc. And the second thing on top of documentation is research. That I come back to conclude to my initial observation. We need sound research in Israel that converts that data into knowledge in order to tell the story authoritatively. And the fact that humanities, I go back to that issue, the crisis of humanities in Israel endangers that also in Holocaust research. And the fact that Israel lost the leadership to other countries in Holocaust research is a shame for the state of Israel. Is a shame for the state of Israel that should be corrected. So documentation, research, and telling the story. Those are our duties for the coming decades, for the coming years, in order to fulfill the tzavah, the last will and testament of Gela Zekstein, of 6 million Jews that were murdered in the Shoah, and of those that survived. And unfortunately, in the future, we will not be with us in order to tell their stories. Thank you so much.
Thank you very much, Dani. And our next speaker is Mr. Greg Schneider, the Executive Vice President of the Claims Conference. And let me just introduce you to the public. No?
It's okay, it's okay.
It's okay?
Google me, yeah.
Okay. Thank
It's
you.
all good. I know. Thank you.
No, it's okay.
Can there ever be just compensation? Is the idea that money, in any amount, and certainly in the relatively paltry sums that Holocaust survivors currently receive, can compensate for loss, murder, beating, starvation, imprisonment, dispossession, torture, and on and on? Is it absurd? I'm reminded of some of the early thinkers like Siegfried Moses, about whom I'm sure we'll hear a lot over the coming days. Was an early thinker on this topic, arguing on the legal basis of Germany and to pay reparations. Like others, including Ben-Gurion, who felt that reparations were essential for the existence of the State of Israel in those early years. But the fundamental question remains, isn't it true that the suffering and loss experienced by almost all survivors is so unimaginably great that the very notion of a few $1,000s or even pensions of a few $100s, even if paid over years, defies logic and is even insulting? Even from the framing of the question, you can probably deduce how I feel. And I speak now of my very personal feelings. As my rabbi likes to say, I'm speaking to myself and letting you listen. For me, two mitigating factors compel us to continue in these endeavors. Although perhaps obvious, I think they bear worth mentioning as the backdrop of all of our discussions over the coming 3 days. The first, very practical. For so many survivors, the money matters. In the early years, money helped young survivors get education and restart their lives. It helped older survivors establish themselves and help build families. And even today, we estimate that 110,000 of the living 275,000 Holocaust survivors live in or near poverty. Let me say it again, because it's probably the most important thing that I will say. 110,000 Holocaust survivors of the 275,000 alive today live in or near poverty, making even the paltry sums important when deciding between food and rent. Second, the symbolic nature of the payments. For most survivors, the suffering in the Shoah was the seminal experience of their lives. I do many home visits, as you can imagine, to Holocaust survivors. And almost always, when I ask about family, they say they have none. They're alone. Now, invariably, the social worker, the caseworker from the agency, the welfare agency that the Claims Conference is funding, will interject or will whisper to me, the survivor actually has or had a spouse. Maybe they have children and grandchildren. But what the survivor means is that the nuclear family, and often extended family, of their childhood is gone. Their parents, siblings, aunts, uncles, and cousins were murdered, and they singularly survived. Especially in old age, when we frequently regress, many survivors' first reaction is to think about the core defining experience of their lives. Over 70 years, compensation, such as the Hardship Fund, BEG, Article 2, CEF, Central and East European Fund, the Child Survivor Fund, have come to symbolize recognition of suffering. The payment, no matter how small, validates the suffering experienced during the Shoah and that of the subsequent 70 years. For surely, the suffering lingers. In addition to physical ailments, the psychological trauma endures, night terrors, survivor's guilt, complicated familial relationships, just to name a few. But what I have grown to understand is that if the compensation payment is acknowledgement, validating the experience, then by corollary, a rejection from a compensation program is invalidating. Basically, a re-traumatization by rejecting, invalidating, undermining the person's core self-identity. And think of the many reasons for technical rejection. The income or assets can be just above a set limit, or the lack of required proof, or even a mistake by a caseworker. But for the survivor, it is not a technical rejection. It can be a major psychological trigger. It imbues our work with far more importance. Yes, for many, the money matters, but it is never really about the money. We are here to discuss developments in Holocaust compensation and restitution during the last 70 years since the Luxembourg Agreements. But my message would be different if this were the 100th anniversary since the Luxembourg Agreements. Then this would be a purely academic discussion, still interesting, but a matter of history. However, because we are still administering and shaping programs, still negotiating and implementing agreements, the past is relevant today. I will examine with you what happened during the last 70 years in one particular case, one example of what we have learned from the endeavors and how examining the past has led to more equitable programs for Holocaust survivors. Any lessons must be viewed in light of the fact that something novel, something new was constructed and implemented. These agreements and programs were revolutionary. Nothing like them had been done before. Despite this, the programs today diverge quite radically from those initial programs. My remarks focus on the programs that aim to deliver compensation payments to individuals. After the Luxembourg Agreements, these efforts were codified in legislation. The German Federal Indemnification Law, Bundesentschädigungsgesetz, known by the acronym BEG. I want to highlight three facets of that original BEG that were completely revised in the subsequent 70 years. Number one, the BEG set forth provisions for awarding of pensions of damage to health for certain persecutees, and this provision became one of the main legislative bases in the 1950s for pensions of victims of incarceration in concentration camps in ghettos. In order to receive such a pension, the victims had to go to a doctor. In most countries, a doctor specified in an approved list of doctors from the German government, and have an evaluation by the approved German doctor of the BEG authorities in Germany of if and how much their then health deterioration was caused with a direct linkage by their persecution. The award of the pension was dependent upon evidence of the damage to health, fixed by the percentage of the reduction of earning capacity, which implemented the amount of the pension, impacted the amount of the pension. Merely being in a concentration camp for less than a year was, and in and of itself, insufficient to obtain a pension. As a result of this agreement, many applicants who were in camps were denied pensions. Now, using today's lenses, this notion is cruel. As I spoke earlier of re-traumatization, can you imagine going through this process, what that must have been like for a Holocaust survivor in those years? Number two, the applicant had to prove his or her own persecution. The burden was on the survivor to submit an application to the German authorities in German and to provide the relevant documentation to substantiate the application. In some cases, the applicant could simply not provide the necessary plausible documentation, could not supply proof that there were a particular camp or ghetto, and thus did not file a claim or filed an incomplete claim, and the claim was denied. In many cases, this led to many applicants also turning to lawyers, with some being better than others, of course, and all lawyers, as still happens today, require a significant payment for representing the survivor. Number 3, given that the application was filed under German law, appeals had to be filed with German courts. Not only were there delays that were lengthy and costly, but as shown by the report of the German Justice Ministry in 2016, the failure of denazification in the German civil service resulted in a judicial system that continued to employ many of the same judges and prosecutors who had worked and implemented Nazi laws during the Nazi era, and by the way, had benefited from the expulsion of Jewish lawyers and judges from the civil service. It was these same judges who would hear appeals from survivors. These and other deficiencies were brought to light by survivor organizations, legal assistance groups such as the URO, the United Restitution Organization, the Claims Conference staff in Germany, and journalists and academics who followed the issues. I point all of this out only because it was due to constant evaluation, analysis, critique of the benefits, deficiencies of the programs, that we can better the programs, making them better, more appropriate for Holocaust survivors. As most of you know, the programs established in subsequent decades, particularly those under the Article 2 Fund agreement, have a totally different framework. By the way, it is called the Article 2 Fund as the obligation negotiated by the Claims Conference to form agreements for those victims of Nazi persecution who had suffered serious persecution but have received no or minimal previous compensation, was set forth in Article 2 of the implementation agreement of the reunification agreement between the two Germanys in 1990. That's a mouthful. It was a lot of words there. But basically, the very agreement that allowed East and West Germany to combine to create the new Germany, the unified Germany, in that agreement, Article 2 speaks of required additional funding for Holocaust survivors. The programs were no longer founded in legislation, but were created as a result of bilateral agreements between the Claims Conference and the German government, and are still to this day administered by the Claims Conference. This framework made the agreements easier to amend than legislation. I'll highlight just a few important ways in which the agreements diverged from the earlier programs about which I spoke. First, the application forms to be completed by applicants today exist in multiple languages. For sure, the forms are still burdensome and likely triggering. But we go to great lengths to minimize the intrusion and always use existing data in the file to help advance further applications. Further, applicants do not have the burden to submit documentation to prove the persecution themselves. It is the Claims Conference, the administrator of the program, that conducts research to assist the applicant, often writing to multiple archives to find proof of the applicant's suffering during the Shoah. The development of an applicant victim-friendly program was a sea change and has become an intrinsic component of all our programs. Consequently, the number of applicants who need lawyers has declined drastically, as many survivors can complete the forms themselves. And in addition, the Claims Conference funds 300 local social welfare organizations worldwide to help them free of charge. Clearly, one of the most egregious aspects of the original law was the requirement to establish damage to health. And through negotiations with the German government, this is no longer required. In modern society, it is and should be unacceptable to state that incarceration in a concentration camp was in and of itself not sufficient for compensation. It should be noted, by the way, that some of these unacceptable provisions still remain. A widow of a recipient who received a damage to health pension can only receive a widow's pension if the widow can prove that the BEG recipient died because of persecution, or that the persecution caused the illness, mostly with the same illness for which the damage to health pension was granted in the 1950s. Anybody understand that? If we don't, how is a survivor supposed to? How is a 90-year-old who has just buried her husband? The requirement is so outrageous and onerous, it is no surprise that very few approvals are granted. Numerous requests asking the German lender, the various land like states, authorities to liberalize this provision have been unsuccessful over the years. Appeals are dealt with in the Article 2 and CEF programs by independent appeals judges, who often request independent historical review to come to a decision, or in one case or another, the appeals judge is himself a distinguished historian. This is a recognition that most often the appeals are not a matter of law, but of understanding the historical circumstances of persecution to determine whether or not the applicant is eligible. During the next few days, we'll be looking at the positive impact and effects, challenges and deficiencies, as well as the lacuna of past and present programs. We will seek to understand what worked, what needs to be changed, where efforts need to be put in the future. This applies to programs of personal compensation and also property, movable and immovable, personal, communal, and heirless restitution. Our hope is to use the conference to help provide us with insights of how changes were made in cases where there were problems, hopefully still guiding us in the future. The open issues before us include ensuring that all poor Holocaust survivors receive at least a modest pension, ensuring that property restitution occurs in countries in Central and Eastern Europe, especially in Poland, which is the only major EU member without any serious property restitution legislation, and addressing issues of looted art and cultural property. What is clear and has not changed is that the mission of the Claims Conference, established in 1951, remains even after 70 years. In the 1950s, the Claims Conference recognized the needs of survivors, either in DP camps or being resettled in new communities or rebuilding destroyed communities, and we negotiated for funds and programs to assist them. Today, vulnerable disabled survivors in their homes need assistance in their old age, and we commit ourselves to negotiate for funds and programs to address their needs. In the 1950s, the Claims Conference used funds of 450 million Deutschmarks to fund the rescue of Holocaust archives, helping establish institutions such as Yad Vashem, the Wiener Library in London, the precursor to the Memorial de la Shoah in Paris, re-establishing EVO, funding the first research of the Holocaust by eminent historians such as Raoul Hilberg, providing a grant to Elie Wiesel for an early version of Night in Yiddish. All in all, an effort to ensure that the history and lessons of the Holocaust are not forgotten. Today, 70 years later, we are still supporting major Shoah institutions like those mentioned, and others such as the United States Holocaust Memorial Museum, preserving archives and making them accessible, funding emerging scholars through the Kagan Fellowship, and literally hundreds of additional programs. Today, some of our methodologies are evolving, funding TikTok influencers, films on the Shoah like Academy Award winner Son of Saul, numbered Who Will Write Our History in 1945, and holograms of survivors and virtual visits to camps. But the purpose, to ensure the history and lessons of the Holocaust are not forgotten, is still the same. Let us learn from the last 70 years in order to assist Holocaust survivors and their heirs during these final years. Thank you.
Thank you very much. I'm honored now to call the Ambassador of Germany, Mr. Steffen Seibert. Mr. Seibert is a German journalist, presenter, and a public servant, currently serving as the German ambassador to Israel since August 2022. Before that, he served as the spokesman of the federal government and the Chancellor Angela Merkel, and the head of the federal government press and information and office. He was also formerly reporter and foreign correspondence, editor, and evening news host for the German television station ZDF, and he holds a master's degree from the Hamburg University, where he studied history, literature, and public law. Please. No? Oh.
Dear Director Stauber, dear Professor Shamir, dear Mr. Schneider, dear Colette Avital, and I would also like to acknowledge Ambassador Dayan for his very thought-provoking speech. Ladies and gentlemen, live here at the Anu Museum and also online, it's an honor to address you today. This international conference, 70 years of Holocaust compensation and restitution, is yet another milestone in what is, oh, there he is, I'm happy to see you, is yet another milestone in this year's cycle of events to commemorate the Luxembourg Agreement 70 years ago. And I think it's a very clever design to have a whole sequence of events throughout the year, both in Israel as in Germany, because this shows two very important things. A, we commemorate this historic founding block of German-Israeli relations together and jointly, and B, our obligations, our responsibilities resulting from the horrors of the Shoah will continue to be at the core of German policy and of German-Israeli relations in particular. Let me just mention a few elements of this sequence of events of commemoration. The German Ministry of Finance and the Claims Conference produced the movie Reckonings, which premiered in Berlin in May and will also be screened here, I understand, and I can only recommend it. It is a very, very interesting piece of work. The Ministry of Finance, the German Ministry of Finance, launched its digital theme portal to enable easier access to relevant files and documents, because, as you said, research is so very, very important. And during his state visit to Germany in early September, President Yitzhak Herzog and the Speaker of the Bundestag, Bärbel Bas, together unveiled the exhibition commemorating the Luxembourg Agreement inside the German Parliament. On the actual anniversary of Luxembourg, our Minister of Finance, Christian Lindner, and Chancellor Scholz welcomed all relevant stakeholders in Berlin, including the Minister of Social Equality, Merav Cohen, and Ambassador Eizenstat. And for those who are especially interested in the personal relations back then, which may perhaps have been decisive, Ben Gurion's home in Sde Boker and Konrad Adenauer House in Röndorf joined for an online project on these remarkable political leaders. And finally, you are all now meeting here and online for a 3-day conference. This togetherness would have been entirely unthinkable 70 years ago when the Luxembourg Agreements were signed between the newly established State of Israel, the even younger Federal Republic of Germany, and the Claims Conference. Signed, we must remind ourselves again and again, signed only 7 years after the end of World War II, only 7 years after the Shoah, after Germany's murder of 6 million Jews in Europe, which is and will always remain the single most horrific crime against humanity ever committed. Very understandably, concluding this agreement was highly controversial at the time, highly controversial in Israel. To sit down and negotiate with representatives of the country responsible for such atrocities was, for many Israelis, an abhorrent thought. Accept money from them was an abhorrent thought for many Israelis, but in the end, they did not prevail. And I believe that this agreement that could be achieved is truly remarkable. It is the foundation of today's strong German-Israeli relations, none of which would have been able to develop if it hadn't been for 1952, I believe. And we will always be grateful for that, and we will never take this for granted. Let's not forget, even though the German compensation system is based on the concept of what we in Germany called Wiedergutmachung, we must be very, very clear, none of the crimes against the Jewish people can ever be made good again. So the word is wrong, misleading. Everyone who has visited a concentration camp or has spoken to a survivor immediately understands this. I will also add that some of the early stipulations of the programs that you just mentioned to us are very hard to listen to if you're the representative of the Federal Republic of Germany, and I'm glad that they could be overcome, or in many ways amended. Adenauer, I think, understood clearly that this young German democracy needed to be very clear about the crimes of the Nazi era, the crimes of Germany, needed to take full responsibility and needed to express this responsibility towards the Jewish state in a tangible and practical way. And we, to this day and into the future, understand that payments can never replace memory and, above all, can never replace passing on the facts, teaching the facts to every new generation in Germany. This is the responsibility we have to fulfill towards the survivors of the Shoah, who narrowly escaped the persecution of the Nazis and their collaborators, who survived the industrialized mass murder in the concentration camps, who suffered beyond imagination in the ghettos, who fought the Nazis in the resistance, and while they survived, lost their families, friends, and loved ones under terrible circumstances. Many survivors, it's been mentioned, live today under difficult conditions. Given their high age, the pandemic put an additional burden on their health. And this is why the governments of Israel and Germany took joint efforts to provide additional funds for survivors in Israel, to facilitate additional hours of home care, to cope with some of the most difficult consequences of the pandemic. This additional agreement between the German Ministry of Finance and the Claims Conference was finalized in September. This, I think, is exactly what is meant when we say there is a permanent commitment carried forward. This is exactly what it's meant. Only last week, I had the opportunity to go to one of the care homes for Holocaust survivors in Rishon LeZion, and I saw how JCC funds are used to give these women, it's mostly women, a life in dignity, give them meals, give them some comfort in their old age. Lichyot Bechavot is the name of the organization that does sterling work there and in other places, and I really want to commend them for this work. And of course, as always, when you meet survivors of the Holocaust, you just listen to their stories, you go away in awe of their strength and their spirit. But as a German, you also go away in shame because of what they had to endure. And that is why it's so good that during the conference in Terezin 2 weeks ago, the governments of Germany and Israel agreed to jointly preserve and systematically archive as many testimonials by survivors as possible. We must care for and keep listening to the testimonies of the survivors while they are still among us, while we are still fortunate to have them among us, because they strongly remind us and all future generations of the need to fight anti-Semitism vigorously and relentlessly and in every shape and in every form. Of course, as a German, I would wish that 1,700 years after the beginning of German life in Germany, we could say that we have overcome anti-Semitism. But unfortunately, and you all well know that, that is not the truth. We haven't overcome anti-Semitism in Germany. It is still there, and the number of incidents is troubling. Anti-Semitism even seems to serve as the one toxic uniting factor in conspiracy theories that otherwise are quite incompatible and seem to have nothing in common. Last week, we commemorated the November pogroms of 1938. During these days, several hundred German Jews were murdered, many more were arrested, sent to concentration camps. Synagogues and places of worship all across Germany were burnt to the ground, cemeteries vandalized, shops and apartments looted, and then set on fire. The November pogroms foreshadowed the unspeakable crimes of the Shoah committed a few years later. These November pogroms were a state-orchestrated and organized outburst of violence after many, many years already of discrimination, of harassment, of hostility. And millions of Germans stood by passively, perhaps many out of sympathy for the Nazi ideology of hatred, perhaps also many because they were afraid for their own lives. But the bottom line is they stood by passively while their neighbors, their acquaintances, in many cases their friends' lives were destroyed. There's the stark warning for our times. Resist the beginnings is one such warning. Don't stand by passively when they turn against your neighbors or people of another religion. That's another warning. Germany, my country, its government, and all its democratic institutions are committed that we will never accept or tolerate any attempts to deny or distort the Holocaust. It is an undeniable fact. It is a singular crime against humanity. It cannot be compared to any other event in history, and it shall never be forgotten. I'm therefore convinced that the joint commemoration of these events, the Luxembourg Agreement, our joint efforts to support survivors and preserve their testimonies, and your exchange in the coming days will make an important contribution to this important endeavor, and I thank you very much for letting me be here, letting me a part of this, and listening to me. Thank you very much.
So now we will watch a pre-recorded short greetings from former U.S. Ambassador Stuart Eizenstat, Deputy Secretary of Treasury. Mr. Eizenstat is an American diplomat, an attorney. He served the United States as ambassador to European Union from 1933 to 1996, and as the United States Deputy Secretary of Treasury. And for many years, he took a leading role as a special representative of the President and the Secretary of State on Holocaust-era issues in the campaign for reparations for Holocaust survivors.
Thank you for inviting me to say a few words at the opening of your important conference. I'm recording this today as I'm preparing literally to leave this afternoon to Prague for a follow-up meeting of governments and NGOs to the Prague conference of 2009 that led to the Terezin Declaration. I took the lead in drafting that Terezin Declaration as special advisor to Secretary of State Clinton during the Obama administration. While we'll be reviewing and discussing open issues and challenges in the areas of Holocaust compensation, restitution, and education at what's now called the Terezin II conference that will begin Wednesday, and Thursday of this week. The topics being examined at your academic conference remind us that we shouldn't take for granted that we're having these talks at all, the ones in Prague this week and indeed yours, because the whole concept of compensation to individuals and restitution of property to communities and individuals that began in the 1950s, that was signified by the Luxembourg Agreement of 1952, whose 70th anniversary we just commemorated in Berlin last month was groundbreaking and revolutionary. Never before in history had it occurred. Never before had a defeated nation, here Germany, paid compensation to individuals that it had harmed. Never before had an NGO been created, really out of thin air, to represent a group of civilians who had been injured. Here, of course, Holocaust survivors. This was
to invite Professor Milette Shamir, the Vice President of the International Affairs of Tel Aviv University. Professor Shamir is also a researcher in the field of the American Studies at the Faculty of Humanities, and she joined the university in 1998 after earning her PhD from the Brandeis University. Her research is about the 19th century literature and cultural history, and it has been published by Columbia University. Among many things that she did in our university, I'll mention that in 2012, she founded the Tel Aviv University pioneering undergraduate program for international students, the BA in Liberal Arts, and served as the academic director until 2016. Please.
Thank you very much, Roni, Mr. Dani Dayan, Mr. Greg Schneider, Ambassador Seibert, distinguished guests and participants of the conference. It's my delightful task, I have to say, to be last in this panel and to simply greet you on behalf of Tel Aviv University at the opening of this important conference on the 70th anniversary of the historic Holocaust reparation agreements. A conference that, beyond, I think, having a great significance in terms of its topic, is also to be commended as a collaborative venture and as a multidisciplinary venture, as Roni spoken about earlier. Collaborative because I think a conference of this weight and magnitude can only be the product of the cooperation of multiple bodies. In our case, this includes the Goldstein-Goren Diaspora Research Center, the Minerva Center for Human Rights, the Faculty of the Humanities, all here at Tel Aviv University, Yad Vashem, of course, the Claims Conference, Anu Museum of the Jewish People, who are hosting us in this beautiful facilities, the Jacob Robinson Institute for the History of Individual and Collective Rights at Hebrew University, and the Leo Baeck Institute for the Study of German Jewish History and Culture. So it's a collaborative venture. It's also a multidisciplinary one, because as any short glimpse at the program will clearly show, one of the achievements of this conference is to bring together a variety of research perspectives, historical, legal, cultural, social, economic, and more, with the goal of significantly promoting an understanding of the complex historical events that were the 1952 Holocaust reparation agreements, and offer insights as to the ways in which these agreements shaped, and I think everyone will agree, will continue to shape the present moment. The question of how the reparations agreement influenced and enabled relations between Germany and Israel since the 1950s is, of course, an intriguing one, and it's relevant, I think, to almost any domain of life here in Israel, including, I might say, academic relations, and here I bring my own perspective as Vice President in charge of academic relations internationally here at Tel Aviv University. And I'd like to just mention to you that at Tel Aviv University, German academia is our chief partner, second only, I think, to the United States. And this has been so now for several decades. Our first exchange agreement with a German university was signed almost 4 decades ago, and since then thousands of German students have come to Tel Aviv University, and a similar number of Israeli students spend time at German institutions. German, the German language, is one of the most frequently taught languages on campus. Tel Aviv University has more than 50 agreements with German institutions and universities. And particularly after the establishment of the bilateral research funds, first the GIF in the 1980s and then the DIP in the 1990s, we've partnered in literally thousands of joint research projects that were developed by Israeli and German scholars with the participation of Tel Aviv University. Just to give you one number, in the last 5 years alone, 1,700 research projects took place through the cooperation between Tel Aviv University and German universities. And one wonders, in the context of this conference, whether this extraordinary academic traffic and exchange and collaboration would have been shaped differently had it not been for the history of the Israeli-German relations as it took shape in the early 1950s. But of course, the ramifications of the Holocaust Reparation Agreement stretch on a much, much wider canvas than academic relations, and are indeed, I think, to be considered on a global scale. As Roni has mentioned, I'm an American Studies scholar myself, and I'm fascinated by this one single example of the way in which the agreements and the precedents that they set now take part in the ongoing debates in the US about reparations for slavery. And while it is difficult and controversial, and as the ambassador cautioned us, it's not desirable to launch comparisons between different human tragedies, the Holocaust and slavery. And while the actual economic model of the compensation of 1952 is of very little use, I think, in thinking about reparations in North America over slave exploitation, the agreement, very interestingly, provides an inspiration for current debates in the US. And I'd like to bring as just one example an article that was published just a few years ago in the Atlantic magazine by Ta-Nehisi Coates, who is one of the leading African-American intellectual voices in the US today, where he relies on Ben-Gurion's words about the reparations agreement to build his own case for slavery reparations. Coates quotes Ben-Gurion, who, I don't have to tell this audience, has said that, this is a quote, "For the first time in the history of relations between peoples, a precedent has been created by which a great state, as a result of moral pressure, takes it upon itself to pay compensation to the victims of the governments that precede it." These words for Coates issue a moral challenge to the present US government to accept responsibility for the past. The lessons that Coates learns for the 1952 agreement is that, and this is another short quote, "An America that looks away is ignoring not just the sins of the past, but the sins of the present and the certain sins of the future. More important than any single check cut to any African American, the payment of reparations would represent America's maturation out of the childhood myth of its innocence into a wisdom worthy of its founders." I think much can be said about this strange and surprising coalition here between the founding father of the Zionist state, Ben-Gurion, and a contemporary progressive African-American intellectual. But this is not the place to expand upon these strange bedfellows. I just offer Coates' words as yet another example of how the agreement continues to live on and to live in and to permeate debates and exert influence in multiple contexts around the globe. The importance of researching the Holocaust that Dani, Dayan, and my other predecessors in this panel spoke about is indisputable. Not just creating more and more quality research about such events as 1952, but also making sure that they are made public. And here, just again to bounce off of what Dani Dayan has said, there's great importance of reinforcing the humanities and Holocaust research here locally in Israel, but also let us not forget, after all, this needs to be the product of collaborations between researchers here, researchers in Germany, and around the world in order to truly grasp the significance of events such as the Luxembourg Accords. And this indeed brings us to today's conference. I want to thank, on behalf of Tel Aviv University, all the participants who agreed to contribute their research to this conference, to congratulate all the partner institutions who helped put together such an impressive program. I want to especially thank the Goldstein-Goren Diaspora Center and its head, Professor Roni Stauber, and his assistants, Sarah and Adi, for taking the lead in organizing the events of the next 3 days. And I wish you all a very successful and fruitful conference. Thank you very much.
Thank you for inviting me to say a few words at the opening of your important conference. I'm recording this today as I'm preparing literally to leave this afternoon to Prague for a follow-up meeting of governments and NGOs to the Prague conference of 2009 that led to the Terezin Declaration. I took the lead in drafting that Terezin Declaration as special advisor to Secretary of State Clinton during the Obama administration. While we'll be reviewing and discussing open issues and challenges in the areas of Holocaust compensation, restitution, and education at what's now called the Terezin II conference that will begin Wednesday and Thursday of this week. The topics being examined at your academic conference remind us that we shouldn't take for granted that we're having these talks at all, the ones in Prague this week and indeed yours, because the whole concept of compensation to individuals and restitution of property to communities and individuals that began in the 1950s, that was signified by the Luxembourg Agreement of 1952, whose 70th anniversary we just commemorated in Berlin last month, was groundbreaking and revolutionary. Never before in history had it occurred. Never before had a defeated nation, here Germany, paid compensation to individuals that it had harmed. Never before had an NGO been created, really out of thin air, to represent a group of civilians who had been injured. Here, of course, Holocaust survivors. This was totally new and novel. I'm showing you the cover of a law review article that I wrote for the University of Pittsburgh Law Review in the winter of 2021, called The Importance of Novel Legal Solutions to Provide Belated Justice to the Victims of the Holocaust, because this indeed was novel. Academic research is critical as it demonstrates what governments and NGOs can and should do, the frameworks that have been successful and those that have not been successful, and the impact of the programs. It shows us that national governments not only have to deal with their own compensation and restitution issues, but also have to show leadership and responsibility and work together to develop best practices that can influence other countries that have not yet developed comprehensive programs of compensation and restitution, and affect sharing best practices. It reminds us that those leaders in early years, such as German Chancellor Konrad Adenauer, Israeli Prime Minister David Ben-Gurion, and Nachum Goldman, the head of the World Jewish Congress, who organized 23 Jewish groups to create the Jewish Claims Conference, took real risks. Commencing negotiations was not popular in their own countries. Indeed, it was unpopular in many quarters, but they persevered. So these leaders persevered because they knew it was the right thing to do for survivors, and it was the right thing to do for the countries they led. That's the mark of a true leader. It's clear that in order to move forward in this complicated and emotional issue of compensation, true leadership was required then, and it's required now. The lessons you're discussing at the conference are not only lessons for history and academic research, but are very relevant today. I'm sorry I can't be with you, but I look forward to viewing recordings of the many varied and interesting sessions you've planned. The adage, those who failed to learn from the past are bound to repeat it, has never been more relevant than it is now. We need to learn from the last 70 years of Holocaust restitution and compensation in order that the final chapter of these efforts can be as transformative, non-bureaucratic, and impactful as possible. So thank you for permitting me to participate in this way, and have a great conference.
Thank you very much for all the speakers. So now we move to the keynote speaker, which is Professor Konstantin Goshler, and the respondent is Professor José Brunner, and we are really proud to have such a distinguished and leading scholars in this field at the beginning of our conference. So Professor Konstantin Goshler wrote some of the pioneering works on our topic. He studied German literature and linguistic and ancient and modern history at the University of Munich, where he was awarded a PhD. And he was a lecturer in modern history at the Humboldt University of Berlin. He taught and researched at the Charles University Prague, and then also in Harvard University, the University of Vienna, and Ruhr University of Bochum, where he was appointed a professor of modern history. And currently, he is the Gerda Henkel visiting professor at the London School of Economics and Political Science. And Professor José Brunner is a professor emeritus at the Buchmann Faculty of Law and the Cohen Institute for the History and the Philosophy of Science and Ideas at Tel Aviv University. Currently, he also serves as the academic director of the Wiener Library for the study of Nazi era and the Holocaust. Brunner is the co-director of 3 international research projects examining compensations proceedings for Holocaust survivors and forced laborers. He served as an expert advisor to the State Commission of Inquiry into the treatment of Holocaust survivors in Israel, and the co-founder in Tel Aviv University of the first Israeli legal clinic for the right of Holocaust survivors. So first, please, Professor Goshler.
So thank you very much for the kind introduction. Being invited to give a keynote address here is a great honor and an even greater challenge, since I must deal with 2 very different demands. On the one hand, there's the legitimate interest of an organization that can look back on 70 years of successful work for Jewish victims of the Shoah to see this work honored. And it is in the nature of any organization that looking at the past primarily serves above all to make sure of their identity and to strengthen them for their upcoming tasks. On the other hand, there's the professional ethos of historians, and this means avoiding short circuits between the past and the present. Hence the question arises, what categories, standards, and perspectives a historian may use to approach the topic of Holocaust compensation and restitution and reparations? My impression is that the peak of public and scholarly interest in the issue of Holocaust reparations lies in the past. In the 1990s, when Stuart Eizenstat's phrase, "finishing the unsettled business of the Holocaust," used to be the slogan of the day, the boom of Holocaust reparations also inspired numerous historical studies, many of them created as a result of large historical commissions. When in the new millennium, political interest in Holocaust reparations sharply decreased, with some delay, the interest of historians declined as well. Today's scholars of Holocaust restitution are no longer driven by heated public and political debates on the matter. However, this situation also offers an opportunity to clarify some fundamental problems that have shaped historical engagement. A first caveat is directed at the use of the term Holocaust reparations. When in 1951 a unified Jewish organization was established for the purpose of receiving and distributing compensation for Jewish victims of Nazi persecution, it was consciously labeled the Jewish Conference on Material Claims Against Germany. Emphasizing material claims was intended to demonstrate that moral claims were not up for discussion. Furthermore, there was no explicit reference in the new organization's name to the actual crime to which these material claims referred. It was, so to speak, a crime without a name. This conceptual situation only started to change in the 1980s. During this decade, several newly established Jewish organizations challenged the entitlement of the Claims Conference to represent all Jewish compensation claims. In 1983, the American Gathering of Jewish Holocaust Survivors and their Descendants was established, followed several years later by the Center of Organizations of Holocaust Survivors in Israel and the World Federation of Jewish Child Survivors of the Holocaust and Descendants. The names of these new organizations indicated not only the rise of the Holocaust as a unifying metaphor for an ultimate crime, but also the career of the phoenix-like survivor, which had risen from the ashes of the traditional notion of the victim. This change of concept from passive victim to active survivor was at the same time associated with a new claim to agency that challenged the traditional understanding of the Claims Conference. Finally, after resolving the conflict among the groups over their respective places in the field, the newer organizations became members of the Claims Conference. And beginning in the 1990s, they commonly led a renewed political struggle under the heading of Holocaust reparations. The emergence of this term was marked by the conflict of two developments after the end of the Cold War. First, the quest of US foreign policy for a new legitimation of its international role. And second, the neoliberal transformation of former East European communist countries into market economies, a process that also reopened the question of ownership of one's Jewish property in these countries. Finally, the notion of Holocaust restitution became the cornerstone of powerful legal campaigns in US courts of law. Historians should therefore always remain aware of this conceptual history. A second caveat targets the role of historians themselves. In the realm of Holocaust reparations, the boundary between historians and activists has often been blurred. Many authors have told a not enough version of the story, highlighting the problems to achieve reparations for Holocaust victims and pointing at the remaining deficits of reparations. One danger of such an activist perspective that identifies with the victims is that possible competitions are reinforced rather than analyzed. But the opposite historiographical approach, which relies on emotional detachment, also has its pitfalls, to which Saul Friedlander drew attention in his famous correspondence with the German historian Martin Brochard. According to Friedlander, the insistence on the ethos of sobriety that German contemporary history for a long time had taken as its banner implied the discrediting of Jewish historical narratives as subjective, as biased due to the Jewish experience of the Holocaust. Hence, the dilemma for the study of Holocaust reparations might be described in the following way. We must reflect on our own positionality without retreating to an epistemological tribalism. Finally, a third caveat concerns the question of uniqueness of Holocaust reparations. When a second wave of reparations for Nazi victims began after the end of the Cold War, it was also in the context of the rise of transitional justice, which was rooted in the post-Cold War optimism of the 1990s. Yet expectations that liberal democracy might be a globally irresistible force against all forms of dictatorship and authoritarian rule have since then largely faded. The question which had emerged in the context of transitional justice of the extent to which Holocaust reparations can serve as a model for other cases of mass violence has therefore increasingly migrated into post-colonial debates and is negotiated there primarily under the concept of genocide. So instead of the victims of autochthonous liberal dictatorships, the focus is now primarily on victims of colonial violence. This is where I see a major challenge to the study of Holocaust reparations at the moment, especially given the renewed political charge. So where should historical investigation of Holocaust reparations go? My following remarks will highlight three prospective research areas which appear especially important to me. Let me start with the role of biographies, property, and temporality. Holocaust reparations have distinguished between compensation for damaged life and material restitution for lost property. German compensation for Nazi victims was based on an individualistic concept that chose the social position before persecution as a point of reference. Only since the 1980s, the idea of lump sum benefits that would no longer reproduce the social differences that had existed before the persecution gradually gained the upper hand. And finally, in recent years, when the plight of aging and needy Holocaust victims received greater political attention, the pattern of compensation for actual losses increasingly has been replaced by support in cases of acute need. Over time, then, Holocaust reparations underwent an evolution from social relief through personal compensation to charity for the elderly. Individual compensation is tied to the finite nature of human life. Attempts to extend Holocaust reparations to the descendants of survivors have so far found little support. Claims for an intergenerational extension of individual reparations are based on psychological concepts of trauma and more recently also on biological concepts of epigenesis, that is, the genetic transmission of traumatic experiences, which brings biology into the play again. Even more, in recent years, it has been asserted that not only the experience of the Holocaust itself, but also the experience of Holocaust restitution procedures possesses important transgenerational dimensions. Reparations, according to historian Nicole Imler, are not only, quote, an instrument of recognition of historical injustice, but also an instrument of intergenerational communications in the families of survivors, unquote. In addition to individual claims for compensation, there have also been claims which aimed at the losses of the Jewish people as a whole. Dan Diner even argued that the notion of Jewish collectivity received a decisive boost through restitution. Part of the compensation payments to the Claims Conference then served to rebuild Jewish communities around the world. Unlike individuals, collectives, such as the Jewish people, are not bound by the limited duration of human life, which widens the temporal perspective. This also forms a bridge to property claims, which often outlast the span of an individual's life. The long time horizons involved, however, create significant problems, especially since the relationship between property and those who make property claims after a long time often becomes very complex. However, the permanence of property rights clashes with the peculiarity of law to set limitation periods to ensure legal certainty. And this also applied to the restitution of Jewish property after 1945. Thus, it aimed not only at the rehabilitation of Jewish victims, but more generally also at clarifying ownership of assets, which in turn was a prerequisite for the re-establishment of a liberal market economy in West Germany after 1945. The latter also applied to East Germany after the collapse of state socialism in Eastern Europe after 1990. While the restitution of real estate was handled relatively quickly, the dispute over the restitution of works of art has a longer time dimension and is still ongoing. Yet the strong media focus on outstanding and expensive works of art is ambivalent. Not only does it contribute to a distorted image of Jewish social history, moreover, the associated fantasies of Jewish wealth, as Ron Zweig called it, can also reflect old anti-Semitic stereotypes. You should read his fantastic book on the Hungarian gold ring. Added to this is another problem. Individual objects of art have often become a point of reference for local identity in the decades since they were lost from Jewish hands, especially when it comes to prominent museum objects. The communities of heirs and their lawyers are then often accused of only being interested in money, which of course can easily strike the strings of the old anti-Semitic lyre. Thus, seized or looted property not only acts as a repository of Jewish memory, as Dan Diner has pointed out, rather it can also be enriched over time with the memories of those who have owned it in the meantime. This is at least partly the reason for the sharpness of some current restitution conflicts. Temporality with regard to property also means that different layers of memory can attach themselves to the same object and become part of it. Last but not least, different understandings of temporality also have shaped the relationship between Jews and Germans after 1945. For the Jewish side, the question of compensation always has been inconclusive, since there can be neither an equivalent for the damage suffered nor a limit to the duration of an individual's life. This is also the reason for the permanent cycles of disappointment on the German side, who always has accepted new negotiation packages in the hope of reaching a final settlement at some point in the future. Thus, in restitution negotiations, the Jewish side often instrumentalized not only the belief in the power of world Jewry, which continued to be subliminally effective on the German side. It also has exploited effectively the eternal German longing for a final settlement by repeatedly announcing that just one more concession would be rewarded by the subsequent return of the longed-for peace. To conclude my first point, history, anthropology, psychology, and other disciplines could cooperate fruitfully in the study of such problems. The investigation of the mesh of different temporal structures with the contrast of individual and collective approaches to restitution offers numerous approaches for interdisciplinary research. Perhaps then the old question can be answered anew and better. How and when, if at all, this process can one day come to an end? This brings me to my second point, which is about the meaning of law, life worlds, and agency. In 1964, Hannah Arendt explained in a famous conversation with Günter Gauss that for her it was not the year 1933, but the day when she learned about Auschwitz that was decisive. Quote, "That was 1943, and at first we didn't believe it. It was really as if the abyss had opened, because people had the idea that everything else could somehow be made good, just as in politics everything can be made good. Not this. This should never have happened." Unquote. And to a certain extent, the policy of reparations also took this circumstance into account, in that the Jews murdered during the Holocaust by no means played a central role in it. Rather, it was primarily about the rehabilitation and compensation of a fraction of those people who had suffered and survived one of the many facets of National Socialist terror. What may be seen as an unforgivable deficit of German reparations, namely not having provided adequate compensation for Auschwitz, is thus in a sense also a product of the impossibility of making the associated events the subject of politics. And in this very sense, the term Holocaust reparations is misleading. Consequently, there has always existed an unsurmountable tension between those aspects of the Holocaust that remained excluded and those that were amenable to legal regulation. In addition, legal regulations always live from the drawing of boundaries, from inclusion and exclusion. And so there is an irreconcilable tension between individual demands for justice and the norms and practices of reparations legislation. And by establishing certain principles at the genesis of reparation legislation, attempts by the Claims Conference and other actors to extend their scope were inevitably bound to use the source code once established, and thus to accept certain path dependencies. In 1983, Ernst Katzenstein, then the director of Claims Conference Germany, expressed his despair that the subjective territoriality principle had been accepted in the Luxembourg Agreement of 1952, which provided in principle that only Germans would be entitled to compensation. As a result of the territoriality principle, Katzenstein wrote, the extent of compensation was usually inversely proportional to the severity of the persecution suffered, since the persecution of foreign Jews was usually much worse than the persecution of the German Jews. And he considered it as a major failure of the Claims Conference that it had not tried to get rid of this principle on the occasion of later revisions of the German compensation law. Instead of this, all possible legal sophistication had been used to define Jews from Eastern Europe as Germans in order to get them into the law, with sometimes bizarre consequences. And for individual Holocaust survivors, it was often simply incomprehensible why the same fate of persecution was sometimes compensated and sometimes not. Such observations point to the fundamental tension between law and justice, about which many theorists have racked their brains. The German social philosopher Jürgen Habermas, for instance, considers law as a hinge between system and life world. He also believes it is possible to arrive at binding principles of justice by way of a non-hierarchical discourse. Can this optimistic perspective also be applied to Holocaust reparations? Habermas has been challenged on this point by French postmodern philosopher Jean-François Lyotard, and I'm following here a discussion that José Brunner undertook some time ago. With a view above all to Holocaust victims, Lyotard distinguishes two different rules of judgment. One, where a rule of judgment is applicable for both sides, and another one, where the regulation of the conflict, quote, is done within the idiom of one of the parties, while the wrong suffered by the other is not signified in that idiom, unquote. Consequently, the victim needs to abstract from its own experience by using the idiom of the other side, while becoming a plaintiff who will be listened to, quote, the victim will be silenced, unquote. Unlike in the situation described by Habermas, at least as a theoretical option, from Lyotard's perspective, the victim's agency is mostly denied. At first glance, this theoretical explanation seems to fit all too well those popular narratives that describe the reparations procedure as a kind of second persecution, describing the work of German compensation administrations even as a, quote, guerrilla war against the victims, unquote. Certainly, one might find many examples to support these harsh accusations. In 1974, Benjamin Ferenc, you can see him here in the middle, the young man, next to Nachum Goldman, one of the foremost legal activists in the field of Wiedergutmachung, described the attitude of the Bavarian State Compensation Administration as, quote, precise, pedantic, narrow, restrictive, and absolutely inhuman, unquote. The reason for his harsh judgment was that this agency strictly denied any connection between the severe psychological disturbances of a 70-year-old Jewish woman and what had happened to her in Auschwitz, including the murder of her son and her husband. Ferenc summed up his disgust, quote, Wiedergutmachung, ach, unquote. There is plenty of empirical material with which to write the history of Holocaust reparations as a scandalous story. And this, in fact, has been done many times, especially since the 1980s. At that time started a campaign for forgotten victims, which focused on Sinti and Roma, victims of forced sterilization, deserters, homosexuals, and other groups whose discrimination had not ended in 1945. What role do these experiences now play in the narratives of Jewish survivors? To answer this question, I looked at a selection of 950 transcribed and searchable interviews taken by the Free University of Berlin from among the 55,000 interviews held by the Shoah Foundation. The word Wiedergutmachung, reparations, appears only in 139 of the 950 interviews, which in itself is an interesting finding. Apparently, the use of the term was frequently only triggered by the questions. The interviewers often introduced this question with a sort of excuse by suggesting that Wiedergutmachung must have been a sham. So in an interview with Anna Fischer, a Jewish survivor, in 1997, the interviewer asked, and now that's the question, quote, and how was it? It also might be an odd question because there is no actual Wiedergutmachung, but did you get some sort of Wiedergutmachung anyhow, unquote? The answers still await a systematic historical analysis, and certainly also the questions. But some trends are already emerging. Again and again, interviewees describe the bureaucratic procedures as complicated and time-consuming. And while reparations very often were considered inadequate, nevertheless, in many cases, they made a difference in the sense that after the Holocaust, they were helpful for rebuilding shattered biographies. A short version of this narrative comes out in an interview with Clara Rajek, a Jewish woman born in 1910 in Budapest, who later moved to Israel, where she was interviewed in 1997. Quote, "And afterwards, I successfully fought for German Wiedergutmachung, and from that time on, I was able to build a more pleasant and better life," unquote. Of course, there are many much less positive examples, not least those cases in which Jewish survivors received no compensation at all. Psychologist Ilka Quindo, who also conducted many interviews with Jewish Holocaust survivors, described how many of them quite readily answered questions concerning their persecution, but how they often became reticent when she inquired about their experiences with reparations. She argues that these interviews involved a particular dynamic of interaction. The murder of relatives or one's own suffering, quote, "cannot be made good again, and therefore the question on reparations brings the survivors in a psychological difficult situation, especially when put by a non-Jewish German person," unquote. In any case, a systematic investigation of the discussion of reparations in interviews with Holocaust survivors should attend carefully to the conversational situation which profoundly molded the narratives. Are we in a better situation to explain the role of Holocaust survivors in the bureaucratic process of reparations if we look at the records produced during the procedure itself? In fact, it is confirmed there that very often it was almost impossible for the victims to translate their personal experiences adequately into the legal language of the German indemnification law. This was related to another phenomenon that can always be found in standardized legal procedures. Claimants learn during the procedure to distinguish between more or less successful narratives, which leads to a remolding of the stories they tell, and this was also true for Holocaust compensation. Furthermore, the claimants sometimes had to adapt the narratives to changing legal rules, which in turn could generate mistrust on the side of compensation authorities. And after many years of applications and ever new compensation programs that emerged especially since the 1990s, the applicants sometimes even no longer knew exactly to whom and for what they were applying. So there emerges another field of historical inquiry. To what extent can we find an appropriate legal language after experiences of extreme violence? And does the split between the language of the law and the narratives of the victims mean that the victims simply have no voice? Or have they also been able to develop counter-strategies within restitution procedures? The challenge for historians is then as follows. How do we avoid trapping Jewish survivors in a passive victimhood role without simultaneously falling into a resilience narrative that takes a kind of the survival of the fittest as its standard? Finally, I want to discuss a third area for future research, and how far Holocaust reparations have served as a model for other cases of genocidal violence. As a historian, I first look back and distinguish between four phases. First, in the early 1940s, in the course of emerging post-war planning, the US State Department began to consider future compensation for German victims of Nazi persecution by the German state. The starting point for this was not the murder, but the forceful expulsion of ransacked Jews from the German Reich. The political rationale behind these considerations was to set an example that would prevent other dictators in the future from using forced migration as a weapon against democracies. In retrospect, this argument proved to be very far-sighted. Second, the ratification of the Luxembourg Agreement in 1952 was accompanied by angry Arab protests because of fears that Israel would be strengthened by West German reparations. In this context, the argument appeared on both the US and the West German sides that the agreement could serve as a model for compensation for Palestinians expelled from their homeland after the First Arab-Israeli War of 1948. In the following years, the reference to the Israel Agreement's possible exemplary effect on a solution to the Palestinian refugee problem served primarily the purpose of countering the GDR's ongoing criticism of West German contributions to Israel. In this way, Bonn attempted to stabilize the delicate balance of its relations between Israel and the Arab states in the Middle East. Third, after 1990, against the background of the then temporarily achieved position of the Holocaust as the benchmark of a universalistic, human rights-oriented morality, the demand of finishing the business of the Holocaust emerged. The liberal universalism that temporarily prevailed after the end of the Cold War went hand in hand with expectations of an increasing juridification of international relations. The rise of transitional justice, for which German reparations often served as a reference point, was also part of this context. Finally, a last phase has only just begun. For some years now, demands for war reparations from the context of the Second World War resurfaced, for example, by Poland and Greece. At the same time, however, demands with a colonial reference are increasingly being raised. There, however, we can often find a difficult relationship with Israel, which revolves above all around the Israeli-Palestinian conflict. Therefore, Holocaust reparations play either no role at all or at best a negative role in this context. As an example may serve the negotiations that have been ongoing for some time between Namibia and Germany about reparations due to the genocide against the Herero and Nama in what was then German Southwest Africa at the beginning of the 20th century. In this context, in 2021, the supreme leader of the Ova Herero, Vekui Rukoro, expressed shock at the agreement that had been reached in the meantime, since representatives of his own ethnic group had not been able to participate. As South African historian Byron van Wyk reports, Chief Rukoro, quote, also accused the German government of racism because it had negotiated with the Israeli government and several Jewish community organizations, but refused to do so in the Namibian case. Rukoro saw the reason in the fact that Jews and Jewesses were white, while Ova Herero and Nama were black, unquote. This quote marks an important discursive shift. In the 1950s, had dominated accusations, which were also gleefully promoted by the East German GDR, that by means of reparations to Israel and the Jews, Bonn was supporting a colonial policy toward the Arab states. In the current post-colonial discourse, the old accusations are reviving in a transformed way. Now it is no longer the strengthening of Israel resulting from the Luxembourg Agreement that is criticized, but the alleged racist privileging of Jews against reparation claims from the black side. At the same time, Bonn has also shifted its line of defense. In the early 1950s, it had attempted to resist the argument made by Israel in the Claims Conference that due to the exceptional nature of the Holocaust, their claims were not comparable with debt claims of other nations, which were negotiated at the London Debt Conference at the same time. During the recent negotiations with Namibia, however, it became obvious that the German political insistence on the singularity of the Holocaust has also become a perfect political device to insist on the singularity of reparations for genocidal acts. Let me end with a little reference to Benjamin Ferencz, now over 100 years old and still pretty active on social media. He shaped the Claims Conference in numerous functions for decades, starting in the 1950s. But already since the 1970s, Ferencz shifted his interest more and more from backward-looking Holocaust reparations to forward-looking peacekeeping, thereby trying to use his symbolic capital as the last living prosecutor of Nuremberg. In this way, he embodied one of the possible responses to the Holocaust, which led many to think he was a crackpot in the 1970s and 1980s, before rising in the 1990s to become a symbolic figure for supporters of a rule-governed world order that would ensure the outlawing of genocidal violence. Not only his heart is probably bleeding in the face of current developments due to the Russian war of aggression against the Ukraine, which crushed any hopes that Nuremberg and Wassenaar might be starting points for a more peaceful post-war world. While admittedly, I am suspicious of such teleological narratives anyway, all possible answers to the question of what we can learn from Jewish reparations for the future have become even more uncertain than they were before anyway. I look forward to this conference and believe that we will have much opportunity to discuss, argue, and then get along again. Thank you for your patience.
Thank you, Konstantin, for this inspiring keynote, a tour de force, I think, in which you provide many thought-provoking insights into developments of 7 decades. Roni and the organizing committee, thank you for inviting me to respond to Konstantin's talk. Now I can see you, that's very good. At the opening of this conference, it is a great honor for me to address you here, participants and distinguished guests in this hall, and also the people at home on Zoom. Konstantin, you rightly pointed out that pointed to a number of historical transformations on the road from Luxembourg to today. You took us back to the first stage of the process, the agreement of 1952, whose 17th anniversary we are marking today. You pointed out that at this stage, the concept of the Holocaust was not yet part of the discourse on compensation. It came up neither in German legislation for individual compensation, nor in relation to the German global payments to Israel, which were defined as payments whose purpose is to cover the costs of the resettlement of refugees. You highlighted various junctures on the path from Luxembourg to today, underlining how each of them has been marked by different historical consciousness. You rightly pointed out, for instance, that the Claims Conference saw each new stage since Luxembourg as an opportunity to submit new claims, find new victims, give emphasis to new harms, and emphasize new crimes in order to develop arguments for additional compensation. This has been done in a strange dance with a German counterpart who entered the dance floor, that means the negotiations, at Wassenaar and Luxembourg, but attempted to use various historical opportunities to leave the floor, the negotiating table, or at least to ease the grip of the dance partner to make the dance less costly, as the German finance minister Christian Lindner tried to do just a few weeks ago. Sometimes Germany looks like a willing partner to the dance. Sometimes the Federal Republic moves like someone who does not know how to cope with his partner's ire when he does not want to dance anymore, but continues to perform the expected steps anyway. The first time that Germany clearly expressed its reluctance to continue this dance was already in 1965, when it legislated a new law on the compensation of Holocaust victims, the successor to the BEG that has been mentioned here by Greg Schneider. This law was called Bundesentschädigungsschlussgesetz. I think only German speakers can really savor the full resonance of this title. Let me just say this is the only compensation law in the world that announces in its title the wish that what it offers, compensation, Entschädigung, will finally come to an end. That now will be Schluss, an end to compensation claims. The title of this law very much represents the spirits of the 1960s in Germany, both in its intention and in how wrong those were who thought they could legislate an end to Holocaust compensation. Germany wanted to draw a boundary in time, to stop the dance. The end of 1969 was to be the end of compensation claims by Holocaust victims, not of compensation payments, of course, but of new claims that could be submitted. Konstantin, you rightly said, legal regulations always live from the drawing of boundaries, from inclusion and exclusion. There are plenty of boundaries in these laws, and Greg Schneider also pointed to some of them. Some that make more sense, some that make less sense. In my response to your rich and comprehensive presentation, I want to retrace the steps through which you took us, adding an additional angle, bringing Israel into the picture, whose representatives also sat at the negotiating table. You can see there Moshe Sharet. In other words, the purpose of my response is to complement the picture you drew, zooming out a little bit, perhaps looking at developments from a wider angle. By looking at the 7 decades in the Luxembourg Agreement from this wide angle, my purpose is to highlight surprising parallels in the development in Israel and Germany. It is on these parallels that I want to focus my response. So let us go back to 1952 to Wassenaar and Luxembourg, where Germany faced representatives of both the Claims Conference, Nachum Goldman, and Israel, Moshe Sharet, in complex negotiations, and agreed to compensate Israel globally and the Holocaust victims individually. Beyond the many boundaries that were explicitly discussed and drawn there, boundaries with legal value, the Israeli-Jewish-German relations were marked by additional discursive boundaries that were not spelled out, but that were no less powerful for that. They were based on an unspoken, implicit agreement between all sides involved in the Luxembourg process, which you mentioned, Konstantin, not to mention the Holocaust. This was the most important discursive boundary that ruled the first stage. All sides agreed not to talk about morals, not to talk about the past, not to talk about murder. Instead, as you pointed out, the focus in the negotiations and agreements was material and it was future-oriented. All sides agreed, as it were, that compensation could become a reality if all these matters remained silent. If they referred only to the wish of all to strengthen themselves economically, politically, materially for the future. And undoubtedly, there was a need for all sides to be strong against enemies that threatened each of them from the east. West Germany felt threatened from communism, Israel from its Arab neighbors. In the Luxembourg Agreement, Germany agreed to pay compensation to Israel and the Holocaust survivors to gain acceptance into the American defense system against communism. Israel sought a global payment to the Jewish state due to economic hardship that the war of 1948-49 had imposed on it. To make this global payment possible, Israel added a letter to its agreement with Germany in which it denied Holocaust survivors that lived in Israel the right to claim compensation from Germany. I think one should repeat this. The first official document on the rights of Holocaust survivors to individual compensation that Israel formulated and submitted in international negotiation is one in which it denies Holocaust survivors the right to submit claims. This denial then led to the need to legislate an Israeli law to compensate Holocaust survivors. Germany, in turn, added a letter specifying that Israel had to buy goods, especially from West Berlin, with the global payments it received from Germany. Thus, the same money that allowed Israel to buy raw materials and industrial goods for its purposes also subsidized the industrial infrastructure in West Berlin. If there ever was a win-win agreement, it was the Luxembourg Agreement. And to conclude such an agreement, it was not useful to stir up the ghosts of the past, even the recent past, and to moralize. There are additional interesting discursive parallels that characterize this first stage of the 1950s. At that stage, Israel did not define itself as a country of victims and survivors, but of pioneers and warriors. Germany did not define itself as a country of perpetrators. The hundreds of thousands of Holocaust victims who had reached Israel kind of disappeared in its then very present-oriented society. Often, they changed their names to become Tzabarim, real Israelis with no past. Moshe Tehillimzuger from Rovno, then Poland, now Ukraine, became Dan Ben Amotz, the quintessential Tzabal novelist and publicist. Ludwig Pfeiffer from Würzburg became Yehuda Amichai, one of the leading Hebrew poets of modern Israel. Of course, the perpetrators disappeared from the German public sphere. Often they too changed their names to hide their past. So there are interesting and ironic parallels here, I think. And I want to continue with these ironic parallels. They exemplify the complex dance the two societies performed through the decades, which goes far beyond negotiations and compensation. On both sides, the first change came in the first half of the 1960s. In Israel, it came with the capture of Adolf Eichmann in 1960, his trial in 1961, and his execution in 1962. In Germany, it came with the Auschwitz trial that ran from 1963 to 1965. In both countries, a legal event turned the past into a legitimate part of public discourse. Germany started to discover perpetrators in its society. Israel started to discover victims in its society. Both societies focused on themselves in that trial. Although Israel put Eichmann on trial, it was the over 100 witnesses who testified in public on the persecution who formed the core of the trial. Their voices were heard through the radio all over the country. In the Auschwitz trial, it was the perpetrators who formed the center, while the victims were sidelined. Then came the late 1970s. I'm moving on. This is just a response, not a whole new talk. Strangely enough, it was the American TV series Holocaust that triggered a new discursive stage in Germany when it was screened there in 1979. As Konstantin stated, that crime had no name until then. Now this American TV series provided a name for a crime in German discourse. In many ways, it was this series that led to a further step in the early 1980s when essay competitions were launched in German schools in which German kids were encouraged to explore the past of their village, town, or neighborhood. In 1990, the German film Das schreckliche Mädchen, Nasty Girl, based on the true story of Anna Rosmus, dramatized what could happen in such instances. Thus, in the 1980s, the memory of the Holocaust had entered German schools in a broader fashion than in rather formal civic education classes. It turned it into part of everyday discourse. In the end of the 1980s, in 1988, a bit later, but still in the same decade, Israel started school trips to extermination camps in Poland. Thus, in Israel too, the Holocaust started to play a bigger role in school life and in the experience of Israeli school kids in general. The Holocaust turned from a discursive object that was talked about mainly on Remembrance Days and visits to memorial sites to an event to be experienced retrospectively. As Konstantin mentioned, grassroots organizations of Jewish Holocaust survivors emerged. In the end of the 1980s, the Israeli radio also started to broadcast the names of millions of Holocaust victims on the Holocaust Remembrance Day. Until then, names were not really part of the ceremony. The Holocaust victims received a name, as local perpetrators received names in Germany. And the Holocaust became a school experience in Germany and in Israel. The big event of the end of the 1980s and the beginning of the 1990s was, of course, the fall of the wall and the reunification of Germany. The Claims Conference immediately realized the historical opportunity this event offered to Holocaust survivors and brought about the establishment of the Article 2 fund that Greg Schneider mentioned, which led to monthly pension payments for tens of thousands of Holocaust survivors who hitherto had remained outside the boundaries of compensation legislation. Germany was celebrating its newfound unity and ready to enter a new dance, or to continue the old dance, depending on how you look at it. Distinctions that had been drawn carefully at Wassenaar and Luxembourg, such as that between war and persecution, broke down. In the mid-1990s, an exhibition called Verbrechen der Wehrmacht, Crimes of the Army, shocked the German public that had been accustomed to a strict distinction between the criminal SS and the clean army. In the beginning of the 2000s, a foundation was set up to compensate forced labor and slave labor that until then was considered to be part of the war and not of persecution, and hence no compensation. New perpetrators were recognized as well as new victims. The tide had turned. The reunited Germany no longer sought to safeguard a halfway decent reputation by relegating the perpetrators to a minority, or by starting to pride itself on its inclusive politics of remembrance and on its policy to compensate everybody, on offering some form of compensation to all victims. From the safe distance of more than 5 decades, it found a new pride in becoming the world champion in compensation, Weltmeister in Wiedergutmachung, as some cynical voices put it at the time. This gave the Claims Conference a new handle to force Germany to continue to expand compensation to ever new groups, among other places in annual meetings where its delegates meet those of the German Ministry of Finance to discuss compensation under the regulations of Article 2. Article 2 payments are monthly pensions that are substantial. They may make a difference in the quality of life of survivors who by now are elderly people, very elderly. They serve a social purpose. They are addressed to the needy. However, other payments to Holocaust survivors are neither tort, neither for damage, nor social in nature. They are one-time payments and often rather small. Their purpose is symbolic. They are meant to bestow recognition of victimhood on the recipients. This may be too little, too late for some recipients. It may mean much to others in their very old age. I'm not sure how one can generalize. However, it is interesting to note, as was the case throughout the 70 years that formed the topic of this conference, Israel made a very similar move at around the same time. First, in the mid-1990s, Israel allowed the submission of new compensation claims under its own compensation law for Holocaust victims, which had not been possible since the end of the 60s. Then in 2007, it legislated the first law that has the word Holocaust survivors, Chok Hatavot Nitzolei Shoah, the term Holocaust survivors in its title, offering a series of additional financial benefits to Holocaust survivors. In the same year, the government department in charge of implementing compensation for Holocaust survivors also changed its name, and for the first time actually used the term Holocaust survivors in its title. It is called Authority for the Rights of Holocaust Survivors, which was not, its previous name had nothing to do with Holocaust survivors. Also in 2007, the state controller published a critical report on the support offered to Holocaust survivors in Israel, followed in 2008 by the report of the Dortmund Commission of Inquiry, which Roni mentioned I was the expert advisor to. There is no doubt, in this first decade of the 2000s, Holocaust survivors achieved a new status in Israeli society. They were no longer victims, they were survivors, and they had become a kind of hero. The Jews who had lived through the war in Libya, Algeria, Tunisia, Morocco, and Iraq submitted claims for compensation as Holocaust survivors. This has never happened in that way before. They wanted their persecution and suffering too to be recognized as part of the Holocaust. This is not the place to enter a detailed discussion of the various decisions of the Israeli Supreme Court where these claims were adjudicated. Let me just say that some received full recognition and monthly pensions, while others received small annual amounts, a kind of consolation prize, meant for purposes of recognition only. So let me conclude. It seems that in the first decade of the 2000s, all who suffered in some way of persecution during World War II seemed to seek some form of payment, whether for support in old age or for recognition. Moreover, all seem to receive it, for it has become a matter of pride in both Germany and Israel that such support or recognition will not be denied. Under these circumstances, the old-style legal process set in motion in Luxembourg that builds on distinctions and exclusions is neither necessary nor appropriate anymore. There is much in this development that is to be welcomed. It shows respect for survivors and protects them from having to undergo humiliating examinations in Germany and Israel. In other respects, however, I regard it as bearing dangers. It allows Germany to develop a strange pride and adopt a somewhat paternalistic posture as the world's teacher in commemoration, democracy, and empathy, something which the German ambassador here did not do at all, overshadowing not only the further past, but also more recent problematic aspects of its compensation policy. It allows Israel to foster a self-image of a society entirely composed of victims, of ultimate and absolute victims whose actions, whatever they are therefore beyond critique and reproach. Thank you.